My lord, in regard to item 42, can it come in the next week?
Yes, this is relation of delay.
Yes,
You're for the
I'm for the, my lord,
applicant,
applicant.
applicant.
My lord, so far condemnation matter, your lordship may hear, but then the main matter I'm not prepared today. That's the reason. my lord, I'm paying.
But before we touch upon the main, I think the consideration has to be taken care of.
All right, my lord, in that case, I'll be there. My lord, your lordship may hear the appeal after the condemnation matter.
You want it next week,
Next week.
both the application and the.
Yes, yes.
Who's there for the other side?
Other side, my lord, I'll inform is the petitioner in person.
In person.
Yes. I'll inform.
Okay. He's right, Mr. S. Datta, Learned Senior Counsel, appearing for the applicant stroke appellant. Submits that. Okay, you have to put S, applicants stroke appellants. Submits that. Uh, Since he has some personal difficulties today, he prays that the matter be taken up the next day. Beautiful. So before that, you're right, he also undertakes to inform the learned counsel for the other side.
The petitioner in person.
Sorry, he also undertakes to inform the petitioner in person. Or you say respondent in person,
Yes, responding.
respondent in person. About the prayer made by. Next para in view of the gate. On 17/6.
Obliged.
Madam, I come not 8 minutes. 8 minutes.
Yes, item 8.
Justice, the minute take this matter.
I see.
My lord, this matter may be taken up tomorrow or day after tomorrow, my lord.
I'm
Why, my lord?
Who's
On the
item
last 3 occasions, my
Item
lord.
8.
Item number 8. On 22/10/2025, this honorable court my lord, this honorable court on 22/5/2025 that clearly directed no further time may be given. And on 1/6 this month, 1/6/2025, this matter was listed. He took time. 5/6/2025, he took time again. Intentionally, he took time, my lord, on each and every day. So thereafter,
Intentionally he took time. Okay.
yes, my lord.
But Mr. Counsel, you must appreciate the fact that, see, my brother cannot take up this matter.
Yes, my
That is
lord.
why,
Thereafter, I pray.
unfortunately, we cannot take up the matter.
Yes,
We
there.
have to fix it some other time, next
Yes,
week.
tomorrow or day
We'll
after
give it-
tomorrow, my lord.
Tomorrow again, it's not available.
Or day after tomorrow, my lord.
Therefore, not possible.
My lord, from 15 to my lord, 19, I am.
Monday onwards, there we can have.
My lord,
Then Monday, my
my
lord.
lord, 15 to my lord,
Tuesday.
19, I'll be out of station.
Sorry,
15 to 19, I'll be out of station.
15 to
My
19.
lord,
Personal content.
he did not submit any leave application, my lord. In the course list, his name is not there, my lord. And tomorrow his matter in court number 7, item 22, 26 and 35 is fixed. And before this honorable court, item 32, tomorrow he will be appear, my lord. And he did not submit any leave application. On Tuesday, my lord.
You know, other items we're not concerned. We're concerned with item 10 only, isn't it? No, sorry, item 8.
On 22nd, my
Then my lord 16.
22nd.
22nd.
Yes, ma'am.
Mr. Counsel. He has to be there also, na?
Everything is intentional. Within
But
10
can we
within 10
can we
days,
fix a date if you're not taking up the matter?
Maybe that may fix because the doctor may not take up this matter. Only this that may fix because they have on last second still I in court now 1 minute, so I could not attend it.
then 22nd maybe.
List this matter before any other party, not one of us. Bracket you right, justice. Then one more line, since the learned counsel for the respondent,
Yes, 2.
respondent number 2,
Soulless.
respondent expresses urgency in the matter. Then the matter be listed. 22/6.
I'll-
Your Lordships, item number 3 to 5, we have circulated the adjournment request slip yesterday with the consent of all the parties. Lordship may list this matter after vacation.
You are for the,
We are for the petitioner.
She is for the appellant in 3 and 5. I am for the appellant at number 4.
4, yes, yes.
okay, do you have any objection?
No, let it be after the
So
vacation.
both of you are for the appellants, isn't it?
Yes, yes,
Consent of the other side.
Okay.
have been taken.
As paid for by the direct counsel for the appellants and are opposed by the other side. These matters after the ensuing examination. Holiday to be fixed by the.
Lordship, may I mention item number 24 and 25? I'm thankful to my learned friend, he put to my notice, Lordship, we missed the item. Item 24, BTC, 25, Director of Education, BTC is there.
And before also, the service not complete for the respondent.
What is to be done?
Lordship may be taken up on some other day. As regards service, I have no knowledge because I've not gone through the file. Director of Education, BTC is there. Yeah, it has been informed by my learned friend. I missed the item. But our name be shown in the cause list, my lord. We have missed the item. SC BTC's name be shown in the cause list. And item number 25. BTC also. Lordship.
Five is by the state.
And he said it's BTC.
With it.
24,
25.
Mr. Tikeka is there. And 20.
Yes, Director of, as per in the cause list, not in the cause list, order sheet. Director of Education, BTC, writ appeal 268. So SC BTC's name be shown in the cause list, my lord.
In item 25. 25.
Yes.
What about 24?
So tell you my learned friend is
The
appeal.
full respondent service not complete.
We'll do one thing. We'll pass the order as and when the matter reaches.
Yes, my lord.
No, since we missed the item, your lordship, we missed the item. No
Understand.
file, yes, my lord.
Let the matter be called. We'll pass the order.
May
Necessary.
it please your lordship, my lord, this matter may be taken up on Friday. Retaping, my lord, for a new retaping for admission. Last Monday I had time.
We'll read it.
Yes, for admission. my lord.
Okay. What is the? Eleven or 16?
My lord,
16.
urgent matters, my lord, otherwise, the retaping will be infectious. my lord.
What is the
What
urgency?
happened, my lord, it's a matters pertaining to, promotion of a reserve candidate. But the stay, interim stay was vacated, my lord. That's why I am before your lordship. The
You
post
are-
of
Your appeal is against the interim order.
interim.
Let come out Monday.
As your lordship.
But a little adjustment of item number 21, madam. After vacation, any day.
21 comes with 22.
Yes, madam.
Probably I have come to know that item number 22, my learned friend will conduct the hearing, but he is taking adjournment. So, and this is arising out of same judgment.
Same judgment.
I see.
After vacation, any date,
We adjourn in that event.
What you are mentioning item 21.
21.
Why do you want adjournment?
Madam, my senior is there, my lord, and he will be in another matter for hearing. So it will take probably whole day, my lord.
Your senior, Mr.
He's a secretary, madam.
Because of that.
Yes, my lord.
But this matter is listed for orders.
Yes, my lord.
Let us see what is there. As we'll pass the orders as and when the matter comes.
Right.
May please, lordship. I beg to mention for listing a matter, my lord, initial matter, I am for the respondent, my lord. Any date in the next week, my lord.
Give a date. 16th.
May I please, your lordship? I beg to mention item number 39. Hearing matter, my lord, on behalf of Mr. Sorodip Day. My lord, for the appeal and lordship. We don't have some difficulty. I pray for next week if possible. lordship. 39.
Okay. Mr. Sarodip Day, Learned Counsel appearing for the appellant.
Lordship.
You said to have some person difficult to appear before the court today. Upon a mention made on his behalf by Mr.
D. Gogol.
D. Gogol, learned counsel. Please the matter again
Next week, my lord, it was
in the next week on third.
lodge. High level.
May I please, your lordships? Lordship, I beg to mention item 34. For the respondent number 2 in this case, we have circulated our mentioned memo yesterday.
24.
34.
34.
With the consent of other parties.
I'm appearing for the appeal.
Any objection?
Lordship. Date may be fixed, Lordship, immediately after vacation.
Any request made by the learned counsel of the appellant and not opposed to by the other side. Matter stands adjourned to be listed again on so and so.
What's your Lordship?
Bless.
Yes.
May I please, your lordship? With the consent from the other side, I beg to mention item 10 for adjournment.
When do you want it?
Can it become after vacation, lordship?
You're for the appellant.
Yes, sir.
The request made by the learned counsel for the appellant and not opposed to by the other side.
And
Put appellants, yes. And not opposed to by the other side. Matter stands adjourned to be listed again after the ensuing sum of the patient. You want a date? Date? No,
that may be fixed.
on 23/7.
10.
Yes.
May it please your lordships. Lordships, I beg, with the consent of the other side, I beg to mention item number 2 of today's daily list.
Yes.
Lordship, with regard to the instant PIL, we still have to receive our instructions regarding this current case. That is why we're seeking for an adjournment for today.
How much
Lordship,
time?
After vacation, Lordship.
What kind of instructions are required?
Lordship, there are certain suggestions which has been put by the petitioner of the instant PIL in their affidavit. We were supposed to get our instructions whether those particular suggestions which has been put in the affidavit, whether it can be incorporated in practice. Lordship, that instructions we still need to obtain.
Okay. Mr.
M. Bhuya, Lordship.
On the request of Mr. M. Bhuya, learned counsel. Appearing on behalf of Mr. B. Gogol, learned standing counsel, health department. And not opposed to by the other side. Please this matter again after the ensuing sum of the patient. On a date to be expected.
Much obliged, Lordship.
May it please your lordship?
Yes,
I beg to mention for listing of a criminal appeal, lordship, it's a fresh matter and it was registered on 19th of May, but has not been listed, lordship, till today. So maybe taken up on Friday, lordship.
when did you file it?
Lordship, it was filed on in the month of March, lordship.
March. Give a date then, when it's convenient. 22/6.
May it please, my lord. My lord, with the consent of the other side, I'm praying for some accommodation with respect to item number 12, my lord. In this matter, my lord, our departmental instructions are awaited, my lord.
Well,
12, my lord.
you are for the,
I'm for the respondent, my lord.
I'm for the petition. Appellant.
which respondent?
Finance and Taxation Department, my lord.
Finance and taxation. Okay, why do you want adjournment?
My lord, our instructions are awaited, my lord, in this matter.
Okay, London Standing Council, Finance and Taxation Department is that as instructions are awaited in the matter, we praise that the matter be adjourned
After the vacation,
and be listed again after the ensuing vacation. Counsel for the appellant has no objection. Matter stands adjourned to be listed again after the ensuing summer vacation. On a date to be expected.
obliged, my lord.
Lordship, I would like to mention item 37, Lordship. Criminal appeal hearing, Lordship. I need some sort of accommodation, Lordship. Could not
37,
prepare the-
yes, when do you want it?
Sir, I could not prepare the case, Lordship, due to my personal reasons.
Okay, Mr. S.K. Poddar, London Council for the appellants. Some is that you need some more time to prepare the matter. Therefore, place for 2 weeks time.
Maybe 4 weeks after vacation, 16th of July, Lordship.
Okay, then therefore he pays for adjournment. Dear Papa. Stands adjourned to be listed again after the ensuing summer vacation.
Lordship. Maybe date may to 16th,
Any date?
16th of July. Lordship.
It is item 1 promotion.
May I please, your lordship?
Yes.
challenge hearing lordship is the order which was passed lordship by the learned family court lordship Nalbari. The proceeding under 125 proceeding lordship. Apparently, lordship, I have also seen nothing illegality or illegality there. The only difficulty lordship on my part is that lordship, the amount lordship that has been directed to be paid by me is 5,000 lordship. That is something difficult on my part because lordship, I have to pay around 21,000 in loan EMI. So my salary is only lordship 34,000 something, around 35,000. So lordship, this is the basic ground lordship. Otherwise, there is no illegality or irregularity lordship to proceed. But you'll find the findings of the family court at page 63. Page 63, lordship, para 17, it has been already recorded by the trial court also.
Paragraph?
Paragraph 17 of page 63,
Paragraph 17.
lodge.
Read.
Yes. The next, may I read the paragraph first?
Yes, please read.
The next question arises, what would be the quantum of maintenance allowance? From the evidence of DW1 and the affidavit of asset and liabilities of the second party, it's revealed that second party has monthly income not less than 35,000. From the evidence of DW1, it also reveals that he has a personal loan and car loan, and the monthly installment of personal loan and car loan is rupees 9,701 and 10,630 respectively. Along with the affidavit of asset and liabilities, the second party has submitted the loan statement of his personal loan as well as auto loan. It also appears that the second party has a liability of rupees 20,335 towards the installment of loan amount. The second party has his mother in his family, but mother is a pension holder. So the second party has no liability to maintain his mother. So far, the deduction of monthly installment of the second party has about 1,500 in his hand. The first party is also unable to able-bodied woman, and she is a graduate. So the woman also could not remain in idle, and she could not dependent on the income of her husband completely. The first party in her cross-examination also stated that she has filed DV case against second party and her mother. So considering the living standard of parties and income of the second party, in my considered view, if an amount of rupees 5,000 is allowed to the first party as her monthly maintenance allowance, then it would be justified. So only that part lordship. I am also lordship. I have also not seen anything illegalities in this judgment. Only my difficulty on my part is lordship. Since I have quantum. Since I have
Are you ready to pay?
lordship 3,000, I have consulted my client also. 3,000 he will pay, and his loan is next 2 years. His loan will be lordship closed. So then the second option will be there. She will be able to file another petition under 127 laws.
All right, we'll issue notice.
Laws.
You heard Mr. J. Kalita, learned counsel for the petitioner. Suffers that agreed with the judgment dated 8/4/2026 passed by the Court of Principal Judge, Family Court of Nalbari in case number 04 of 2024 under section 125 CRPC. The petitioner has filed the instant criminal revision petition. The learned counsel suffers that as per the petitioner has been directed to pay sum of rupees 5,000 to the who's the first party?
First party lordship,
The wife
the wife.
to the respondent hearing. Towards maintenance allowance, which according to the petitioner is on the other, is on the higher side. Having regard to his financial condition. Next para in view of above issue notice returnable by 3 weeks. Petitioner to take steps for survey of notice upon respondent by speed post within 3 working days. List again. Please give a date.
15/7. Okay.
May I please, Your Lordship, as per the last order, we have taken the paper publication, Lordship, in this matter, and we have also filed our affidavit with that regard, Lordships.
Paper publication.
Lordships,
Why is it pending from 2011?
Lordship, they haven't appeared. Earlier they appeared, but their counsel left. After that, we have been advised to take steps. We have again taken steps, but they haven't appeared. Then we went to take dusty steps. We went there, but nobody was found there. We made a panchnama there. Nobody was found there. Then again, we have been asked by this court to take paper publication in this matter, Lordship.
This is in respect of respondent number 1.
Lordships.
How many respondents are there? You know,
Lordship, in 3 respondents, Lordships.
the
Lordships.
was earlier disposed of.
Lordships,
Then how was it revived?
by filing an IA, Lordship.
Yeah, I find that A on it. You are Mr.
K. Jain.
Mr. K. Jain, learned. Uh, what are you, CGC?
Lordship, I am appearing on behalf of Mr. SCKL, Lordship.
K. Jain, learned counsel appearing on behalf of Mr. SCKL. SCKL is
For the central access.
SC Central Excise.
Lordship. Standing counsel central access.
Submits that newspaper publication has been made for service of notice upon the respondent number 1 in a substituted manner. Of the newspaper publication was done in the local newspaper bracket Sam Tribune dated
25/3/26.
25/3/2026
2026.
and that an affidavit incorporating the newspaper publication has also been filed by the appellants.
Lordship, it has been published in two newspapers, Assam Tribune and Asomia Pratinidhi.
On 31/3/2026. You have to write one more line. The Assam Tribune after that, no? Also, similar publication has been made in the local newspaper bracket
Asomia Pratinidhi.
Asomia Pratinidhi of the same day. Then the affidavit will come. On perusal of the affidavit and the enclosed newspaper publication, we notice upon the respondent number 1 is accepted to be complete. So, however, since no one represents the respondent number 1 today, we adjourn the matter. Step. Okay, when do you want?
Lordship, in the month of July.
We adjourn the matter to enable the respondent to appear, release the matter after the ensuing summer vacation on so and so forth.
Much obliged. Please, Your Lordship. My lord, as per the last order, my lord, there was an order to file, my lord, today,
22.
to file joint petition, my lord. Yeah, my lord, unfortunately, my lord, he is a paralyzed person. And he was released, my lord, on 8. And though we have my brother, my lord, but they are not pursuing that or filing joint compromise or anything.
No, my lord, as per instruction, my lord, we have approached to the, my lord, our opposite party, but they have informed that the appellant is inside the ICU. Again, he have in ICU. So we thought that it is not the place for discussions the matter and to sign the agreement. So we want that whenever he came back to his home, then we will talk and we will sign the joint petition, my lord. So that is the information I have received, my lord.
My lord, my brother is there, my lord. My own brother who is looking after me, my lord. And if they need, my lord, they could contact my brother, my lord. Husband, my lord, is an,
Will seldom be done by the brother of the husband, is it not?
my lord.
Is he in the ICU or has he been released?
He is released, my lord.
When?
Day before yesterday.
Day before yesterday.
Yes, but before that, we
Next
have-
week.
yes. So we
They
time,
can
my
try to talk with the opposite party, with the appellant. They need an opportunity to talk. He was inside the ICU or
My
he was
lord,
in the
what
hospital.
what I suggest before your lordship is that, my lord, let them discuss with my brother. At the finality, at the arrival of the finality, my lord, then we'll put the signature.
yes.
Let the brother be there to communicate, will anyone?
No
from
one
them?
else, my lord. My son also doesn't look after me.
No, no, no.
My
Even
wife
if the
also.
brother- Even if the brother is there when the discussion is going on,
No.
there is no difficulty.
Yes, sir, let them have the, that is my prayer. Let them discuss with my brother.
Along with my husband, my lord.
The
Not,
husband has to be
Husband
there.
cannot come, my lord. He's a bedridden person.
no, we will go to his home, my lord.
He is not able to talk also properly. That medical document will reveal. Brother, Lord, whatever. Picture and like. This is otherwise, my lord, in a very peculiar circumstances of the case. Right from, my lord, January 13 of 26, my lord, I got a brain stroke.
Who was in the ICU? Who was in
My
this?
husband, my petition,
Appellant, my-
appellant.
Appellant. Appellant is the
The appellant is the husband.
husband.
My,
2 days back, you've come out.
yes.
So now, since you've come out, you have a discussion. We posted again after a week. In terms of the last court order.
My lord, what I want, my lord, is that, my lord, let her discuss with my brother. He will communicate to me.
Why?
Because, my lord, if anything,
Why the brother has to come in between?
my lord, he's a paralyzed person. No one, my lord, my son does not look after me.
No, my lord,
wife
he is
also- Let me
because
make
of,
submission, my lord, please, or you complete it, then
okay, you,
my son does not come. Wife does not come. Last time they filed an affidavit, my lord, only asking for the money matter, my lordship. See their affidavit on the last occasion has been filed, my lord. Lordship, kindly see the affidavit to date there. Ketia file koriছে?
19.5.
On 19.5, my lord, page 125 and 26, your lordship kindly see. And I am fighting for the life, my lord, and they are after my money only, it seems to. Lordship, from the record only, it is not my affidavit. Let them have a discussion, my lord. For discussion,
will not harm anything, my lord. With my brother, he will communicate to me. Because the moment they come, in case of my son, my lord, he's a very arrogant. Even wife also, my lord, if something goes wrong, my lord, then he will collapse. Oh, no. He will collapse, my lord, because he's a already stroke patient. A cool atmosphere is needed. Oh, no. Itu কি দিছে diagnosis past কি CBA to full form কি
We have it after the vacation.
Yes, ma'am.
Mr. Program. Out of vacation.
In the meantime, my lord, because I got the instruction, my lord, now, my lord, they are asking one-time settlement, my lord, alimony. The lawyer from the trial court, he made a call to my junior brother for making one-time settlement. Final alimony.
You have a talk, you see, if things don't work out, we'll see in the next thing. All right.
Now, what I apprehend is that, my lord, instead of doing better, it does not turn to the worse. The moment sun comes or anything hot talks arise, my lord, he'll collapse. He just came out from hospital. That's why, my lord, I am insisting to use my own brother as a media, not for a talk, as a media. That can be my, otherwise problem would be so much.
That is up to you. If you want to use your brother, why do you want the court to pass an order to that effect?
My lord, the moment sun comes, my lord, there will be a chaos situation. Then I'm living up to your lordship, my lord. I'm surviving for the, struggling for survival of my life.
He's right. Parties are represented by the respective councils. Step on 22/5/2026. Now my court has the following on. This abstracted. Today, the council for the parties. Councils for the parties. Suppose that the parties are yet to have an agreement. The matter, since the appellant was in the ICU. Mr. Jay, we have done a counsel for the appellant submits that the appellant has been discharged from the ICU just 2 days back. And he's not in a very good condition. Stop. He also submits that because of his health condition, because of his fragile health, the appellant, the respondent may talk to him, talk to the appellant, to his brother. Stop considering the submission. It's up to the appellant to communicate with the respondent through his brother, if he so wishes. That the matter be listed again after the ensuing summer vacation on so and so. on which date the parties will inform the board as to whether any such agreement has been arrived at between the parties. Subject to what will be submitted on that date, the board will consider passing a forward on this.
Vice Chair.
Yes.
See, this appeal is prepared by the state law, see, against the order dated 8/5/25 law, see, which is in page 24, it starts from page 24.
My lord, before my learned friends, my lord, process, may I just point out, my lord? If your lordship comes to the interim order, this is the matter relates to, my lord, the claim for regulation of service of contractual teachers. And the honorable single just said that since you have regularized other persons by a cabinet decision, you also place this petitioner's case before the cabinet. And let it consider. Now, my lord, when the matter came up before the, my lord, division bench 1, on 4 occasions, my lord, the court desired that it should be placed before the, my lord, before the cabinet, but my lord, the government could not do it because, my lord, the cabinet was not formed because of the elections. Now cabinet has been formed, that instruction,
I have the instruction that law, see, my lord, may kindly come to page 25, law, page 39, paragraph 25. Law. It's not a consideration before the cabinet to place the cabinet law. My lord, may kindly peruse the paragraph 25. Law.
Page 39.
Page 39, page paragraph 25. Law. The respondent number 2 by Mary Lucy by a mandamus of this court is directed to place the matter of the present petitioner before the state cabinet for its kind consideration for regulation of their services as done in the case of 18 numbers of contextual lecturer, Upland College, so and so, so and so, so and so, so and so. It's a positive direction to the cabinet. Not for consideration to the place the matter before the cabinet only. It's a two-part law.
Yes, so
We have
cabinet
come,
may reject also.
that part law.
It doesn't say that cabinet
That is
will
other
have to.
thing. These
Says
other
that
things.
it may be placed before
It's a positive directions for, my lord, may kindly peruse against the language laws. Before the state cabinet for its kind considerations, comma, for regulation of their services as done in the case of 8 numbers of contextual lecturers, Haflong Government College, and 3 numbers of contextual lecturers at Dipu Government College.
This is what you have challenged.
We have challenged it also.
So anyway, if that observation was made by the earlier TV1, give a thought about that.
What's it?
The Chaudhary says that there was some.
on four occasions, my lord, the division bench on a seat, my lord. Although it's not reflected in the order, you place it and let us see. That is what the, my lord, division bench was. Let it come before division bench for my lord regular.
I have no objection. I have no objection. Otherwise, lordship, the intention of the government is that, lordship, it's a positive direction, lordship. The court cannot give a, under 226, cannot give a direction to the cabinet to take a particular decision. This is our stand, lordship. Consideration is the other part, and give a positive direction to the cabinet, honorable cabinet is the other part. lordship.
When do you want it?
Any date, my lord.
That's been for by the parties, this matter. Again. Before vacation,
Before, if possible, ma'am, if possible.
on 24/6. All right?
Wait, please. Your lordship will be pleased to see office note dated 24/4/2026.
Lordship, we received the service report. Ama copy that, sir. এটা দিছে। কেন কেন sorry, sir, I wasn't done as well as now. Ama copy to দিয়া। Top 2, na?
Similar as per my learned friend submission, my lord, service on respondent number 2 is
Lordship, may we please to appoint an amicus for legal aid counsel.
This is a POCSO matter. Amicus for the informant.
Yes.
Notice on respondent number 2, my lord, regarding item number 18, madam.
18
Item number 19.
18, no, sir.
Yes.
This corner, no?
18.
Why these two matters are clubbed together?
So we have to serve notice on respondent number 2.
In which appeal?
In item number 18, my lord.
Sade kota is.
Appeal number 241 of 25. So my learned friend submit that notice is served.
As regards item number 18.
As regards item number 18. In item number 19, no notice is necessary.
19, why not necessary?
My lord, it is that conviction is for 3 years.
2 years.
That is why, my lord, and they were allowed to go on bail, remain on bail, previous bail. So regarding 19, my lord, no problem. Regarding 18, my lord, service is to be served on respondent number 2, my lord.
19, you're on bail.
Pardon?
19, you're on bail.
Yes.
No criteria, the 3 years or 10 years not stipulated.
Previous bail, man. Previous bail allowed.
Lordship, regarding service of notice on the other side, there is no criteria as such. Yes. Yes. Oh, then that is. Lordship, understood. Well, I thought both the cases are POCSO related. Yes. Yes. My lord. Lordship.
Please write at the outset, Ms. B. Boyan, learned additional PPS, I'm appearing for the state, submits that notice has been affected upon the respondent number 2 in criminal appeal number 241 of 2025.
Please, Honorable Islam.
Stop in support of her submission. She has produced a copy of the report given by the who's in charge of the station. That's it. Stop upon perusal of the same. Notice is accepted to be complete. Stop since no one represents respondent number 2. We'll deem it appropriate to appoint 39 Jyoti Das and the amicus curiae to represent respondent number 2 in criminal appeal number 241 of 2020. Then what about the paper book? The TCR not yet called?
This year received, my lord.
Copy of the relevant papers be given to Mr.
So, my lord, the case may be listed on 19, my lord.
Ranjay Das.
Because, my lord,
Honorable
I'm
members.
not on bail. I have completed 1 year, 5 months, 20 days as on today in jail. My lord, it may be listed on 19, my lord. Necessary that matters will be served with notice necessary. Report should be supplied to you.
Objection copy paisa.
On 19, my lord.
Objection copy paisa.
Your IA is pending, is it?
My lord, I is pending. And the convict is 1 year, 5 months, 20 days in jail. Present today. So due to non-service, could not raise the bill.
I said relevant papers, no? You write relevant papers, including the interlocutory application, criminal 741 of 2024.
Check the roll.
Be furnished by amicus curiae. This the gate, when do you want it?
कितने भी सर सर
19.
19 19
Not only for consideration of bail, other
For the IA.
delayed.
IA, only for the IA. Okay, thank you. List again on 19.
objection
For consideration of the IA.
what is sir article
Registry, since the TCR has arrived, the registry shall start the preparation of paper book in the meantime. This is not a jail appeal, isn't it?
but no
At the cost
personal capacity
The cost, at the
not
cost,
a jail appeal.
at the cost of the appellant. Yes. Any report? Ms. Bhuya, any report in this?
Well, sure, I have no papers available with me. I'll collect it from him and I'll do the needful. Oh. Thank you for clearing. Thank you for coming. Thank you.
Sheets are there. What has report? You were there. But she not be there. She I think it's in the judgment itself. It's in the judgment. What about the case? They wasn't provided.
Office not to date here. It's. Little about that. This is a jail appeal. My learned friend is also not having papers with him. Lordship, I'll collect the names from the papers whichever is available in the record. Not to me in personal capacity. Yes. From the concerned file. My lord.
Judgment says Mohammed Ashadul Islam is informant. But in the order, it says the informant is MS Rashida Begum. So, to whom will you give the notice?
Let's see. My lord. Let us see. Yes. Lordship, but judgment starts like this. The informant Rashida Begum lodged in Nazahar.
Okay, come to page 33.
Then
The
page
chart is there. Appendix.
Asadul is the informant. Maybe victim name is Withel.
Judgment says that is the informant.
Page number.
Yes.
You read it out. You read out the name first.
Should the paragraph before the first para, it says that the name will be withheld, it will not be.
No, then
Yes.
Rashida might be the victim and the informant Asadul.
Page 33.
No, there is no page. Rashida PW3 prosecution witness, maybe. Yes. No, maybe same name, 2, 3 persons, it may be there. Let the records come, then enter thing would be.
So that's what we're saying. Since we cannot know who's the informant, the two names are there.
Yes.
There are two informants or what? You have to take steps to serve notice to the informant. And whom will you serve? To Rashida Begum or to Ashadul Islam?
One is also not correct. If the PW2 Ashadul Islam is taken to be the informant, then and the evidence of PW1, the victim, PW1 is the victim and she deposed in the court that informant is a mother. That she cannot, because Asadul cannot be her mother. Some discrepancy. Let the records come,
Let the
then we'll
records
take
come.
steps.
He's right. Since the TCR has not arrived, registry shall issue a reminder to the trial court concerned to send the TCR immediately. Stop. Since the name and details of the informant cannot be ascertained with the materials available before receipt of the TCR, the notice to respondent number 2 shall be considered once the TCR is received.
My lord.
List immediately on receipt of TCR.
Not okay, no, discrepancy. Probably. It is also full discrepancy.
Say respond number 2, isn't it? Instead of that, you write informant. Number 2 is not there still. Okay. Somebody had mentioned this in the morning. It was mentioned in the morning. PJ Saike is not available.
Yes. My senior is out of station, so matter may be fixed after vacation.
So Saike is for which party?
Item number 23, madam. No, sorry, 21, madam.
He is for the,
Three applicant, my lord, Nabi Hussain and.
Hasmat. Another one is Hasmat.
Madam, Nabi Hussain, one Habizur and one Usman Ali. For three.
what about the paper book? Is it required?
Not yet ready. Not yet ready.
Paper book will be required or not?
Required, madam.
Not required.
Paper book required, madam. But at least this one, this is for I only. Thereafter, madam, paper for clearing.
You wanted adjournment, isn't it, in the morning?
Right, madam. Yes,
My question to you is that whether paper book will be required in the appeal or not?
required, madam.
Then PCR is there. We direct them to prepare the paper book. Mr. PJ Saike is for which count, which appellant?
For three, madam, one is Nabi Hussain, one is Habijur and Usman Ali, item number 21.
He's for respondent number 3.
Appellant, madam.
I'm sorry, he's for appellant.
Yes.
Okay, Mr. PJ Saike, learned senior counsel, appearing for the appellant in criminal appeal number 10 of 2026. You said to have some personal difficulty to conduct the case today, and therefore adjournment, a prayer for adjournment has been made on his behalf by Mr. Your good name?
M. Rahman.
M. Rahman, learned counsel. The said prayer is not opposed to by the learned counsels appearing for the opposite party. Stop. Accordingly, the prayer for adjournment is allowed. Next para, it is also seen that the TCR has arrived. Therefore, registry shall prepare the paperwork at the cost of the appellant. List the matter again after the sum of occasion.
May I please your
Get that fixed, madam.
Also, it's
May I please your lordship?
27.
28-7. My presence may kindly be recorded.
Miss,
M. Kumari.
sorry,
M. Kumari
M. Kumari, learned counsel,
for the CBI.
learned standing counsel, CBI,
The CBI.
appears for the same organization.
Obliged, madam.
Much obliged.
May I please, your lordship? Chief, the matter has come for.
They are not received, yes.
NCR is not finished.
This will not file, madam.
Objection is.
We will file.
We'll file, madam, by next week.
It is seen that the TCR has not arrived.
Okay.
Therefore, registry shall send a reminder. Now, List again. So this IA is there, no?
There is a IA for suspension of the sentence and right, fear of bail.
Okay, list again on reciprocity, yeah, okay. And this is, no notice has been issued in this IA.
Lordship, it is under 302.
302.
302, offense is under 302, life punishment.
No, my question was, has notice been issued in the IA?
No, Lordship, because I have not made party, Lordship, because it is not mandatory to make a party. In 302, Lordship, specifically, it requires in the section POCSO Act and
Art, Mr. Your good name?
Lordship, U Chaudhary, Legal Aid Council.
You Chaudhary, Learned Legal Aid Council. Submits that by filing this application, the applicant seeks for suspension of the sentence posed upon the applicant by the Court of Sessions Judge Kamru coming down in Sessions Case number 220 of 2014. Convicting the applicant under section 302 IPC and sentencing to undergo rigorous imprisonment for life, to pay fine of rupees 20,000 with default notice. Issue notice. This R. Kaushik, learned additional PPS, some exception notice on behalf of the state. You have a copy? You have received a copy?
Yes, well, I have received them.
List the matter again with the main appeal. Respondent state may file objection in the meantime. So advised.
Obliged.
Right, for the 24 minutes. Here we got notice issued on 8/5/26 to the sole respondent, services awaited for respondent. Right.
What's it? Item number 25, also service.
You've taken steps otherwise?
No, we have taken all these steps.
When?
The office notice there, my lord. Being awaited. In item 25. Good.
There is only one respondent.
Yes, my lord. The petitioner.
Item 24, you write
24.
await service report from respondent number 1, from the sole respondent.
Lordship. Item 25, our name is not so in cost list, your lordship.
In item
25, lordship.
wait for item 25. I'm on 24 right now. You please cancel the order. You just write like this. Neither AD card nor unsubscribed notice has returned back from the sole respondent. Office to track the postal consignment and put up a note by the next date. Then item 25, what is to be done?
Our name is not so in cost list, lordship.
All right. Ms. Boyan had said something in the morning. BTC.
Not complete. And our name also not showing. It is submissions.
You're for the appellant,
Yes, lordship. PTC.
or BTC is the appellant?
Or-
But name is shown here, D. Saikia, S. Bora, R.K. Musari.
My lord, since BTC's news council is entered in the matter, so perhaps they are not appearing. The last council, my lord, as Bora, they are not going to appear in this matter.
Okay.
Oh.
And what about the respondent? Step was taken,
Service not complete.
step was taken or not?
Earlier card children.
There's one respondent only. Item 25. Thing is, whether notice has been issued, steps has been taken.
Sir, we did.
Huh? On item 25. Very excessive. Please write Miss B. Bhuya, learned senior counsel and standing counsel, BTC, submits that somehow he has missed this item. And therefore prays for accommodation. Stop. She also submits that name of SCBTC may be shown in the cost list. Stop. It is also seen that notice has been served upon the sole respondent by usual process. Stop. Accordingly, notice is deemed to be, the notice is accepted to be complete. List the matter. When do we want it? List the matter again. On 22/7/2026, showing SCBTC, the cost list. And along with writ appeal number 130 of 2026. Where is it, the 24? 26.
Item 26.
As part of office note date is 6/2026, it should be exceed the activity.
Objection also yet not filed.
There's an IA. No notice is issued separately in the IA. Mr. Kaushik, separate notice is not required in the IA.
NDPS, not required. By particular. I don't remember. Not required, madam. They have not made party to the inform.
It does not require notice.
Not the informant.
Oh, minor state required.
State requires, because there is no order. It's just the application, that's all.
Fine.
And without notice, you'll file objection straight away like that. In the appeal, you write, since the TCR is not yet received, office to requisition the TCR, the office to send a reminder to the trial court concerned to send the TCR immediately. List the matter immediately on receipt of the TCR.
24 July.
TCR has to come, it may be before that also. So one more line in the criminal IA, hired Mr. A. Bhattacharjee, learned counsel for the applicant, who submits that by filing this application, the applicant seeks suspension of the impugned sentence. pending final consideration of the main appeal. Issue notice, returnable by which date? 24th July. Mr. R. Kaushik Lanet, additional PP accepts notice on behalf of the state. Do you have a copy?
And I'll collect it from my friend.
Copy of the extra copy of the application be furnished to Mr. Kaushik within 2 days. List again on so and so. That date is there. Objection may be filed in the meantime, we so advised.
27.
Contempt petition minor, and in the meantime, respondent filed SLP, that was also dismissed. And review was also filed, that was also dismissed.
In the month of May, the review has been dismissed. And the matter is under process of compliance, but then since tallying of records from 2000 onwards is required, as far as computation of their dues are concerned, my lord, upon grant of PSM status, would take some time, my lord. Because most of these records are not available and many things have to be reconstructed.
Petition minor.
Please indicate that by way of an affidavit,
My
Mr.
lord.
Pathak,
My lord.
Mr. B. Pathak, learned counsel is paying for the sole respondent.
10 days time may be allowed, sir.
Paying for the respondents. Suppose that the process for compliance of the court's direction is on. And since there are certain details to be looked into, it has taken some time. Considering the submission made, the respondent concerned shall file an affidavit showing the process being undertaken by the next day. List again also.
Short date may be given, well, or some of the petitioner is going.
In fact, 15.7 is okay because some other contempt matter connected is also listed on 15.7. 15.7 should be okay.
Some of.
Let it be on record. See, let it be on record. He'll file an affidavit saying that what steps they've taken. So depending on that, we'll see.
Comply for the purpose of complying. Some similar situation already complied with, take given all benefit, but we are now in facing minor. They file SLP dismissed, review file for delaying tactics, that was also dismissed. Now they are going to say that I need some process. At least the 10 days time may be allowed because there is a specific direction that it will affect.
Mr. Pathak, can you file it before?
I can file it within 10 days, my God. There's no issue on that.
Then
But then I
10
think
days
the
time may
actual
be-
payments will take some time.
Exactly.
It's a question of payment as of now only.
We know. But at least show us what you steps you have taken.
My lord. That we
10
can
days may be allowed.
that we
Just
can.
give a date, earlier date. Just before vacation.
I think on 22nd also on a similar contempt matters have to be listed. My lord.
You have it on 22nd?
22nd, let us
List
have it
on
on 22nd. 22nd and 15 July is another day, my lord. It's 22nd.
22nd March.
All right.
Lordship, the senior engaged counsel, Mr. Dipipura, is on leg in court number 17. So Lordship, the item may be possible for the timing, Lordship.
Yes, your lordship.
47 days long.
No, my lord, the applicant is an outsider, yes, your lordship.
Huh?
Applicant is an outsider who filed the connected liability,
What? It's a third party appeal.
your lordship. I have no. Service jurisprudence. Of course, service jurisprudence.
Whatever you are speaking is be considered while considering the appeal, whether the appeal nice or not.
Your lordship.
Consider a fact. The delay has to be condoned first. They are not for the merit of the appeal.
Your lordship,
They have to find out whether 47 days will make it condoned or not. This condoned, you can be taken. And you know, there are third party appeal in service matter. Will be considered fair.
his interest is not hampered in any way, your lordship. He's a headmaster of a private institution, your lordship. I mean,
Madam, you are for respondent number 4.
your lordship.
See, right now we are concerned with the condonation of delay.
Your lordship.
We cannot go into the merit or otherwise, whether he has the right to file appeal or not. Let the delay be condoned. Then we'll see. If he has no right, then will be dismissed. Are you seriously contesting the delay condonation? Because your objection is basically on merit, not on the delay part.
The court has power to not to condone the delay, your lordship.
Sorry?
This honorable court has power.
Yes,
to condone the
yes.
delay.
We condone the delay. Let the appeal be registered. And you contest on the merit. If he does not have any right to file the appeal, then you submit that when the appeal is taken up. Please write hard, Mr.
TP Bora.
TP.
On behalf of TP Bora.
TP Bora, Learned Counsel, on behalf of Mr. DP Bora for the applicant. Stop. Also had Mr.
T Thakuria for respondent number 112.
T. Thakuria for respondent numbers 1, 2, and 3. And Miss
Hey, Begum.
A. Begum for respondent number 4. Stop. Next para. By filing this application, the applicant seeks condonation of 47 days in preferring the connected plea appeal filed against the judgment in order dated 10/9/2018, passed in WPC number 1169 of 2011. Referring to the application, learned counsel for the applicant submits that the delay is on account of on account of coming to know about the judgment in order belatedly. And that you cancel, okay? He further submits that there is no laches or negligence on the part of the applicant to prefer the appeal, and therefore the delay may be condoned. Next para, learned counsel for respondent numbers 1, 2, and 3 submits that he has no objection if the delay is condoned and that the appeal may be heard on merits. Stop. Learned counsel for respondent number 4, however, submits that the applicant does not have the locus standard to file the instant appeal in view of the fact that What is the case of respondent? In view of the fact that the applicant is the head teacher of a private institution, and also a third party. Stop. It is however seen that at the moment this court is concerned with the condonation of delay application, while the objection raised by the respondent number 4 is on the maintainability of the writ appeal. Stop having regard to the submissions made by the parties and the fact that delays of 40 days, 47 days only, the explanation tendered by the applicant in our considered opinion is sufficient. So accordingly, we are inclined to condone the delay of 47 days in preferring the connected appeal. Stop. It is ordered accordingly. Next line, I stands disposed of as allowed. Then one more line, in view of the like that, registry shall register the writ appeal and list the same for consideration. After a week, right?
If I appear for the petitioner lordship and I'm the opposite party in the alia lordship. In the meantime, lordship, in the connected PI lordship, respondent number 1, the Union of India has filed an affidavit, your lordship. So what lordship would like to propose is that would like to file a rejoinder to the same lordship, which I can also come up together, your lordship.
Rejoinder to the
Affidavit in opposition filed by the Union of India in the connected PI. Would like to file a reply to the same lordship. And I may also be considered on the next date.
you're for the petitioner otherwise.
Petitioner and opposite party in the IA.
And who's the IAS filed by who? What is the IA?
IA is filed by Assam State Jamiat Ulama Lordship. I am for the
Implement.
applicant, yes,
implement.
Lordship, for implement as respondent number 5, Lordship.
Okay.
And
You have
wherein they
objection
have
to that?
filed
We
objection.
object to the same lordship because
Alright.
we have filed our objection otherwise. No?
You have filed an
We
objection.
filed our objection.
So IA can be considered today or some other day.
Some other day lordship. On the next day, we'll file a rejoinder to the affidavit in opposition.
Okay.
I'm also.
Yes.
Lordship, actually my learned friend file is rejoinder to that
There's
It
no
is
pressing
PIL,
urgency
but,
in the IL lordship. We file no objection lordship. It is a matter we are challenging the validity of a particular rule, your lordship. They say they are the representative of a particular section of people, lordship, who will be impacted if this particular rule is deemed to be ultra vires the constitution, your lordship. That is why, lordship, it is very important for us to first file a rejoinder to the affidavit filed by the Union of India, lordship. And then their case can be considered, lordship. I can be kept pending, lordship.
He's right, by filing this application, the applicant seeks completely. As a party respondent, number 5 in the connected PIO. Your good name, please.
I'm N. Gautam, lordship.
Mr. N. Gautam, learned counsel appearing for the petitioner in the PIO, submits that you would like to file a rejoinder affidavit to the affidavit in opposition filed by the respondent Union of India. Respondent number 1, Union of India. And pending the same, the learned counsel submits that the instant consideration of the instant application may be kept in abeyance. Considering these, let the matter be listed. Again,
Okay, 23/7 Thursday, we'll file it in the meantime.
23/7 or 2026. Petitioner may file rejoinder affidavit to the affidavit in the position of respondent number 1.
Matter Mr. D. Nath is appearing for all the state respondents except for item numbers 1 and respondent numbers 1 and 3, lordship. Some time is required, lordship, to obtain the instructions. We have already communicated. Instructions are awaited, lordship. They have filed for condonation of delay of 804 days, lordship. We need to file an objection to them.
How much time?
2 weeks, lordship.
2 weeks time is done. The respondents to file their contract with them. File their objection to the IA seeking condonation of delay.
My lord, a date may be fixed.
You write 2 weeks further time. List again also.
Bless you, lordship.
Can it be, my lord, 15/7? 15/7.
If you have it on 15/7.
15/7.
Maybe. As for please note dated 8/6/2026, my lord, effective that respondent number 4, left his address, my lord. This is why answer notice has been written, my lord. I will take fresh step on respondent number 4 of his new address.
Do you have the new address?
My lord, I have collected, my lord, new address. Earlier he was Nalbari, now he is posted at Bozali, my lord. I will take step, my lord.
Please write office note dated 8/6/2026. Indicates that notice sent to respondent number 4 by speed post has returned back with a postal note with inverted comma. Address he left without instruction. Was inverted comma. What's that without instruction? Those inverted comma full stop. Learned counsel, Mr.
A.K. Azad.
A.K.
Azad.
Azad. Appearing for the applicant submits that he has obtained uh, the up-to-date, updated postal address of the respondent number 4. And submits that he may be allowed to take fresh steps within 3 days. Praise the Lord.
But I'm appearing for respondents 1 and 2.
Any objection to the IA?
I have the
Mr.
45 days delay otherwise. Objection.
I'm for 3 lots.
Chair Fugan, appears for respondent numbers
1 and 2, my lord.
1 and 2, and submits that he has no objection to the application for provision of delay and will not be filing affidavit and will not be filing an objection. Stop. Similarly, Ms. M. Bachaji, additional senior government advocate, appears for respondent number 1. Submits that respondent number 1 will not be filing an objection. This again. After
Vacation.
he has seen summer vacation.
Deeply.
Obliged.
The applicant shall file the amended cost title showing the up-to-date address of respondent number 4 in 2 sets before the registry within 2 weeks.
Deeply.
Yes, and he shall also serve copies of the same to the learned counsels for the opposite parties. You'll get a copy.
Yes.
Madam, there is a delay of 883 days in filing the bill, my lord, since 2023. The dismissal dismissed on 29/9/2023, my lord, and the application filed in March 26. I explain the delay, my lord.
Mr. Chalia,
Lordship, will be filing our objection to the IA, Lordship.
you are for which
I
party?
am appearing for the health department, Lordship. I am
Health.
appearing for all the respondents over here.
You have a new assignment.
Lordship?
Normally you were for the finance department,
Yes, Lordship. Yes,
but now we are paying for everyone
yes, Lordship.
as GA,
No, Lordship, as a standing counsel health department, Lordship.
health department.
Yes, Lordship.
They want to file objection.
Let them file, my lord.
Lordship,
But
there-
it is,
there delay of 800 days, Lordship.
anyway, court can delay up to 7 years also.
Mr. R.P. Sharma, learned senior counsel, assisted by Mr. Miss A. Deka appears for the applicant and submits that the applicant has sought for condoning 883 days delay. The filing the connected appeal. Stop Mr. A. Chalia, learned counsel. Learned standing counsel health department submits that he may be granted for the 2 weeks time.
Lordship.
File objection to the IA. Praise the Lord. List again also.
Then you fix one at 15th of July.
28, 22nd. 20th July.
20 July. Or 20, let me 21 and 19.
Have it on 21 then.
Yes. Available.
May it please your lordship. This is also an application for continuation of delay, your lordship, of 68 days.
Has anyone appeared?
On the last occasion, the ESIC councillor appeared and he showed time to file an affidavit, but affidavit has not been filed.
Yes, I see. What is the full form? Okay, I'm closed.
The delay of 68 days and it's a PSU, so approval and all these things, and they were intervening holidays also. Court holidays were there. Ultimately, 68 days delay has happened. Lordship.
So name is shown SCESI.
Council's name is M. Smith for the other side.
Okay, also Mr. A. Sharma, learned counsel for the applicant is present, but no one appears for the respondent. Despite SCESIC be reflected in the cost list. Stop the applications file seeking the combination of 68 days delay in preparing the connected appeal. For ends of justice, further 2 weeks time is granted to the respondents to file their objection, if any.
Lordship can make it 1 week because there is a direction for payment in this case. The issue is basically the quantum of money to be paid for as a pre-deposit. Well, we have filed an appeal before the ESI court. The issue that is pending is what is the quantum to be paid. Now, the learned single justice person order saying that the amount that has been held by the ESI court is correct and that amount should be deposited. So there is now no stay order. Now that order is there. So there is some urgency in the matter to that extent.
Okay, give a short date.
The issue is we are agreeable with the percentage, but not with the quantum.
We have to pass this hurdle first to
Exactly. Therefore, I was seeking a short date, but they have not appeared. His name has been shown.
24/6. Yes. 24/6.
Any date.
Lordship, in this matter, I'm led by Senior Counsel Mr. M.K. Chaudhary. Lordship, kindly pass over the matter for the time being, Lordship.
Timing can be problem. Timing को भी ऐसे timing को ना
Subject to what you say, we have it next week.
Lordship.
Let the regular bench deal with this.
Lordship.
That's paid for the parties who are to buy the parties, miss the matter. For 19th.
Madam.
May I please, Lordship, this year received Lordship, perhaps paperwork is not ready, Lordship. And your Lordship may.
What about report? Report on number 2, respondent number 3. Any instruction as possible?
That instruction we don't have right now, but I will take instruction again.
Mr. Our particular additional PPSR raise warrant is granted for the 10 days time to get the status report about service of notice on respondent number 2. DCR is there?
Yes, Lordship, receipt.
Since TCR has arrived, registry shall prepare the paper book at the cost of the appellant in the meantime. You right, like shall start the preparation of the paper book at the cost of the appellant. Not meantime. Yes. List the date. Give a date. 37.
May I please, your lordship? Lordship, this matter may be taken up after entering the chief vacation, lordship, because I will have to take instruction. I may withdraw this case, lordship.
What is the matter about?
Matter, lordship. Lifting of NFSA rice, lordship. That
Shifting off?
lifting of NFSA rice, lordship. Under previous
I
scheme.
think all PDS.
PDS article.
Door-to-door supply.
Door-to-door supply, lordship.
You want to take some instruction?
Instruction, lordship.
How much time?
Lordship, later after vacation, I had tried to contact lordship, but he is out of station.
Okay, Mr.
PP Datta, lordship.
PP Datta, learned counsel appearing for the appellant. So with that, he may be granted some time to obtain instructions from his clients. Stop. He also submits that there might be a possibility of the appellant not pressing the matter.
That's it.
Then stop Ms. R. Bhattacharjee, learned additional senior government. Has no objection to the court. You have not listed again.
Lordship.
Deeply applies, Lord.
Your lordship. On last occasions, this honorable court sought clarification from the respondent number 4, under which authority made inaccessible my account.
Under which authority?
Yes, the respondent number 4 has freezed my account since April 2024. And accordingly, this honorable court on last, kindly see last order.
I am appearing for the respondent bank, your lordship, State Bank.
Which bank? Which bank is this? State Bank of India.
Lordship,
What is SBFC then?
private entities, private banks.
Switch.
The respondent.
SBFC. They are part of it. What is SBI?
I am appearing for the State Bank of SBI and the respondent.
For respondent number 3.
Yes, no, lordship, only 4. He is absent today.
Salary account link which no.
Your lordship, he's maintaining his account in the State Bank and
Taken the loan,
lordship,
he has mortgaged his house,
lordship.
you have got, you have taken possession of the house. Why is his salary account not being allowed to function?
The
How do
possession,
you expect him to survive?
the possession was taken by the SBFC, your lordship, not by the SBI.
Why are you holding up the?
Your lordship, there was an arbitration proceeding and there was a direction by the arbitrator.
He has taken a loan from you.
No, lordship,
No.
no.
Then who are you to stop the salary account?
Lordship, there was a direction from the arbitrator. There was a,
On record.
it is not on record, your lordship. We'll be filing our affidavit. I may furnish the record, your lordship. As per the direction of the arbitrator, there's an arbitration proceeding, ex parte.
Where is your party?
We are not a party, your lordship. But the direction was given to us and complying to that direction, lordship,
Did you enter into an arbitration sometime?
Lordship, I want to submit the main respondent is finance company. They illegally obtained this order, all are fraud. That's because
Into an arbitration at any point of time?
no, lordship, these proceedings are false. Yes, because
How do you know about these proceedings?
yes, lordship. Yes, because I am paying regularly EMI
In the meantime, the respondent, SBIFC Finance Limited from different state issuing legal notice demanding more sanction amount or loan amount. I have filed a rejoinder affidavit. Kindly peruse case number 58.
In my humble submission, I also respondent number 2 and 3 are the better parties will be able to apprise regarding this. Your Lordship.
Are they represented?
Yes,
Why?
I as Majumdar, name also reflected in the document.
because respondent number 4 SBI have just complied with the direction. Lordship. Lordship. In view of submissions being made on behalf of the claimant company, documents on record and precedents cited by the learned counsels for claimant company, this tribunal is of the considered view that present case is a fit case for exercising power for award of an extraordinary interim relief. The basic ingredients for availing ex parte interim relief are satisfied in favor of applicant company. Therefore, this tribunal hereby appoints the authorized officer of the claimant company as a receiver, and the receiver has right to approach the employer of the respondent with direction to the employer of the respondent to attach the salary of the respondent. It is also prayed by the claimant that personal immovable assets of the respondents may be attached to secure the interest of the claimant. In view of the same, the immovable assets of the respondents shall also be attached.
I am working in the Assam Police Department.
To approach the employer.
Lordship.
How does the bank automatically keep the account on book?
Lordship, the order was passed.
The receiver was required to do what?
He had to approach the employer of
Who is the
the
employer? You.
Lordship, the state government.
You have an order from the employer?
No, Lordship.
No. And you hold up the entire account? The salary is to be attached. The
Lordship.
salary you need take from some other account.
Lordship.
So, not an order from the. If you like, what of you from the salary? The receiver has to approach the employer.
Lordship.
Employer does not give you taking.
Direction.
Receiver comes and gives you this order.
Yes,
It's not attached the. It does not attach the salary account.
Lordship. Because the order has come directly from the arbitrator, so bank has acted upon it. If there is a direction, your lordship, then we will unfreeze it.
There is an arbitration, there is an order in an arbitral award. Either project, whatever. The order is there.
Yes.
Challenge it.
Lordship, I have not received the notice. Further, I want to state that the arbitrator had directed on 19/3/2024, but the respondent company has been receiving the EMI till 28/8/2024.
Say against the arbitral award. The arbitral award is wrong. According to you, the arbitral award is wrong.
Yes.
Yes?
They suppress the actual fact that they are receiving.
Understand one thing. Arbitral award is wrong.
Yes.
According to you.
Yes.
Have you challenged it?
No, not that, that is false. I want to,
Challenge what?
all proceedings are false, and the finance company trying to take illegally take possession of my property.
So you have to file a writ petition against that.
Yes, all proceedings for praying for setting aside all proceedings.
What is your prayer in the writ? Where is that? Where is your prayer? When will you file the?
Say 1 week time. Case number 15 from the last person. As to why shall not be set aside and passed. The order dated 4/7/24 passed by the additional district commissioner Kasar, as well as the notices issued by SBFC Finance Limited to the petitioner, and or may pass such any order.
Counsel, you file the affidavit incorporating this instruction here.
Lordship.
Posting it next Friday. Okay. He's right, the parties are represented by the respective, no, right like this. This matter has been listed in terms of the order dated 25/5/2026. Stop, Mr. Your good name?
H. Buragohain.
H. Buragohain. Learned counsel appearing for the respondent number 4. Bracket SBI. Submits that. He has received the instructions. He has received his instructions, which is to the effect that there is an arbitral award passed by the arbitrator. On 19/3/2024, by which the bank has been asked to freeze the bank account of the respondent concerned. Stop the respondent. Is the petitioner in the instant. Petition number 1, is it? How many petitioners are there? Sarat Kumar Singh and another. Who's the other person?
Respondent number 13.
Who is the wife?
Wife.
One is the husband.
Yes, husband and wife.
Respond number one.
It is married.
Considering the same, the learned counsel for the respondent number 4 SBI shall file the instructions received by him by way of an affidavit. Oh. Or not before 18th of June 2026. List again on 19th. 9th of June.
Worship, this PIL is regarding implementing the mandate of Section 19 Subclause 1 of the Maintenance and Welfare of Parents and Senior Citizens Act 2007, under which the state has been directed to establish an old age home in every district with a minimum capacity of 150 senior citizens. But the states under this High Court has not complied with this. So here I am seeking mandamus for implementation. Yes, state of Mizoram has filed, only state of Mizoram.
Ms. Bacharji, what is your affidavit about?
Lordship, I have already filed affidavit. Lordship.
Yes, what do you say in that?
Paragraph 12, Lordship. Page 35, Lordship.
There's a chart here showing the old age homes. Does this conform to the requirement?
No, not at all, Lordship. Not at all. Here, the state has to say that this requirement is not mandatory, but if we read section 19(1), the barrack, here it says that the state government may establish and maintain such number of old age homes. Yes, may, the word may is there, but if we continue to read, old age homes at accessible places as it deems necessary in a phased manner. Here, Lordship may take note, beginning with at least one in each district to accommodate in such homes a minimum of 150 senior citizens who are indigent.
That is established in the year 1989.
It is not 18%. It is not state run.
Yes, yes.
Knowledge of the state and it is accepted by the.
Yes.
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 To reply to those, whether it suffices or not.
No,
It is found in that act,
yeah.
number of persons and size given.
No, but the requirement that the state is given that the state is making that they do not require more old age homes, that is not mentioned in the mandate. The state cannot, the executive cannot decide that more old age homes are needed or not. Since the legislature has set the minimum requirement, then the executive does not have the power to say that we are not going to implement it because we don't see the requirement of more old age homes. Here, beginning with at least in each district, a minimum of one old age home is required here. By law, that mandate has been given. Nowhere in the, Arunachal,
I have to complete my instructions, Lordship. Because in Arunachal Pradesh also, there are NGOs who are running the institutions, but it's government funded, but not completely under the control of the government also.
So when will you file your affidavit?
Actually, 2 weeks after vacation.
2 weeks. And Nagaland? Do you have any old age homes in Nagaland? Why? NGOs are running at least. Government is not having.
the government is under a mandate here, Lordship.
The one in Aizawl, it's just below the old High Court building.
Yes.
Few inmates are there. And one in Seattle also. There are a few inmates. You file your reply. What you want to say on the government's counter affidavit. All right. He's right.
P. Barbarua.
Sure.
Deeply obliged. Deeply
Okay.
obliged.
I'm sorry to detain your lordship, but item number 35, 36, hearing, so far 36 is concerned in this case matter, acquittal against acquittal matter, common case matter. A special repetition along with condemnation file matter, 9 days condemnation, delay matter. So if you also condemn the delay, my lord, I think they do not have any objection, my lord. And all right, record already received by. Item 35, along with my main 36, man. Once I am appearing
in item number 35 for the accused and item number 36 for the appellant one. He is victim, appeal against acquittal one.
This 9 others in item number 36. Item 36.
Not 36 one.
There are 9 others.
9 others.
Anybody appeal? 9 others.
Now, yes, they already, by your kindness, see the order dated.
Names are not declared in the post.
Name is there, madam. From 2 to 10, B. Chauhan.
The names are not reflected in the post list.
It is there.
You know that the matter.
So name is there. 36, right side, madam. B. Chauhan for 2 to 10. 36. Your lordship got it. Initially, the file was single bench against acquittal. Thereafter, madam, it was taken to.
Because of the time.
My,
He may not be here. In case when the name may not be, he may not be here at the
other side.
other side.
Let after. Yes,
We'll,
yes.
no, we'll have it at 2 o'clock.
2 o'clock.
May it please your lordship. Lordship, it's an appeal where the appellant is aggrieved from a judgment and order dated 4/4/2026 passed by the learned special judge Poxo Golaghat in special case 11 of 2024, where the appellant has been convicted under section 6 of Poxo Act and section 366 and 342 of Indian Penal Code, where he has to go for rigorous imprisonment for 20 years, lordship.
It has come for the first time.
Yes, lordships.
The issue, you will admit the appeal. Judgment is okay. That Mr.
Gunjan Das, lordship, I'm legally.
G. Das, learned legal aid counsel for the appellate. Submits that the present appeal is filed by the appellant against the judgment in order dated 4/4/2026 passed by the Court of Special Judge bracket Poxo Golaghat in special Poxo case number 11 of 2024, by which he has been convicted under section 366/342 IPC and also under section 6 of the Poxo Act. So on his conviction, he has been sentenced to undergo simple imprisonment for a period of 5 years, to pay fine of ₹5,000 with default clause for conviction under section 366 IPC. Stop. He has been sentenced to undergo simple imprisonment for a period of 6 months for conviction under section 342 IPC. And lastly, he has been sentenced to undergo rigorous imprisonment for a period of 20 years and to pay fine of rupees 15,000. The default clause for his conviction under section 6 of the PROCEEDINGS. Next para. Let the appeal be approved. Call for the TCR. Issue notice to the state as well as to the informant. Mr. R. Kaushik, additional accepts notice on behalf of the state. You have received a copy? Therefore, no formal notice is required. Notice be served to the respondent number 2, bracket informant. To the jurisdictional police station. Stop. Copy of the notice in proper format be furnished to the office of the learned addition or the needful. The officer in charge of the police station concerned shall thereafter report back about the service of notice to the informant. We've gone one step ahead about the informant. He must be mentioned somewhere here. Oh, he's already responded.
Only responding.
Oh, you already made him a respondent. Oh,
Yes,
very
Lord.
good. List again on receipt of the TCR.
Mashallah.
You are there? You have received a copy? No, this is matter P.
Method.
Okay. Very small. I guess. That appears for the appellant where the matter is called. Just again after.
My learned friend is present, my lord, but who received the notice for us from Mr. Chauhan. Post sir.
Appearing 36, my lord. In criminal league.
36 two alia, my lord, one leave, another is condemnation, my lord. So far this. There are two yes. Two material lawsuit fine, 36 with criminal leave petition material lawsuit fine, number 3424.
Yes, what is that leave petition?
Leave petition is special leave against acquittal, my lord.
Acquittal, okay.
In fact, that is not required now, my lord. Your lordship. Leave it was filed long back, my lord. Now, as per Supreme Court decision, leave is not required, my lord.
Leave against acquittal no more
Against
required.
not required. But the victims, idea 372, your lordship, victims can file without review. But it was filed under 378. Wrongly by this section was put, my lord. I don't know that subsequently I entered in the, I have an idea my Prime Minister, other person with my lord. So leave is there with your lordship will find IA number 844. That is my lord condemnation. 9 days my lord delay. In fact, in that.
Regarding leave not required, what is the any decision?
Yes. Sorry, madam. To Malika, Thirteen point two. Victim state file could have.
If state prefers, then leave is required.
Yes. But if victim file, my lord, then not required.
Leave is filed under what section?
It was filed at 378, but actually it is 372 miles. Because victim is here, it is victim.
I understand.
Yes, 372.
372 is victim.
Yes. So here also victim file, madam.
372 CX.
So, madam, those survey. Then if you. How is it between? Yes, 78 says, but if it is filed under basis of complaint, then leave is required. If it always a complaint. So it is not on basis of complaint, but it is GR case by the government, investigation by the police. So why should it be 370? 372 year was.
378 is leave.
372.
378 is the leave again.
Yes.
It is by the
should-
state.
Yes. If it is filed under basis of complaint, then leave is required. Only.
But you have mentioned as 378 in your.
That is what I am saying, madam. Only it has spoken. That is what I am saying.
Then what about 35?
35 is my lord against conviction. We have come. And 36 against acquittal, madam. We filed a court case. That is 36. In that case, they got acquitted, madam. In the case which we filed, they got acquitted. The case they filed, we got convicted, my lord. That is 35. Appellant of 36, my lord, is one of the accused in 35.
How many accused persons were there?
5 persons, madam. That is so only one of the victims
35 is against conviction.
against group.
That is the
That is against
36 against acquittal.
It was initially filed for single bench, man. Not a single bench called for the LCR also. Man. Thereafter, madam, ultimately it was checked with this case, man. Order data proposal. Civil. Check for the. Yes, 6 to 26, madam. In item 36, you also will find. Order data 6 to 26. LCR has come. So, madam, my prayer is that, madam, let the delay my subject to madam first. 9 day delay, I think, given an acquittal, madam. Maybe condone leave, maybe leave is not required. So, in the along with this, madam, this may be posted, madam.
Along with 35.
Yes, along with 35. And in this case, madam, we will file deposition on our own, madam. Otherwise, it will get delayed, madam. Because item 35 is 24, madam. It is our year 24. Same doesn't send anything. तुमसे का दोषी
Item 35, there's no order to be passed as of now. No orders
Actually,
required.
it is the complete paperwork we got, my lord.
Sorry?
It is complete in all respect. We got the paperwork also. It is ready for hearing, my lord.
Right. There's no order to be passed at this stage.
No,
is
no,
it? Only 36.
only 36, man.
This is 36. What do you say about the condemnation part?
As far as the continuation concerned, I have no objection, but my lord, the granting leave, my lord, I have objection, my lord. Because very reason order passed, my lord, everything, my lord, discussed. All the medical, my lord, report. It is not clear, my lord.
Leave is not required. What objection you will make?
My lord,
See, the victim herself has filed the appeal. And thereby the way question of the requirement of leave has been waived.
leave, my lord. Because, my lord, it's a reason order passed, my lord, equating, my lord, of the 9 equity.
That's on merit. You will argue on merit. Leave part, we don't go into that because leave is not required. Okay. And paper book not required. You said you'll
Submit the deposition, madam, on our own, madam.
Okay.
That will do, madam. Otherwise, it will get delayed, madam. So because
Okay, please write in criminal leave petition, okay? Heart Mr. H.R.A. Chaudhary, Learned Senior Counsel, assisted by I.U. Chaudhary for the petitioner who submits that. The instant, what's that? This one. The instant leave, the instant criminal leave petition has been filed inadvertently under section 378, subsection 4 of the CRPC. Whereas in view of the proviso under section 372 of the CRPC, no such leave has been contemplated if the appeal is filed by the victim herself. The Learned Senior Counsel submits that the same has also been fortified no, not 45, has been reiterated by the apex court in the case of Malik Arjun Kodakali. I'll repeat again. Malik Arjun Kodagali versus State of Karnataka, 2019, 2 SCC 752, which again was referred by the same court in Joseph Stephen and others versus Santana Sami and others, 2022, 13 SCC 115. Stop be there for submits that the main criminal appeal may be taken up without the instant revocation, subject to, of course, the delay being controlled. So, you're Mr. Chauhan, no?
My lord.
Yes.
Two
Yes.
to 10.
You're appearing on your personal capacity or as a legal aid counsel?
No, but I was there, engaged back now.
Engaged. Mr. S. Chauhan, learned counsel, appears for respondent number 2 to 10. And submits that since the trial court has passed a reasoned order, leave may not be granted. Stop. However, right like this, the fact, however, remains that in terms of the provision, as already stated here in above, there is no requirement of leave to be granted when the appellant is the victimized. Therefore, the objection raised by Mr. Chauhan is found to be not tenable. The respondents, of course, will have liberty to argue the matter on merits. Even the appeal is admitted. Stop considering the above. No orders are required to be passed in the instant petition, and therefore the same stands closed. Then what about condemnation?
My lord, condemnation, I have no objection.
No objection. Not Mr. Charit Chaudhary, assisted by so and so. Suppose that my file this application. The applicant seeks condonation of 11 days in filing the connected appeal. So please read the sentence, for example. Stop referring to the application. The learned senior counsel submits that it was on account of the applicant being detained in jail that could not file the appeal on time. And therefore, the delay being unintentional and on bona fide grounds, the application, the application for condonation of delay may be allowed. Stop, Mr. S. Chauhan, and council agreed for responding to this. 2 to 9, 2 to 10.
2 to 10.
Fairly submits that he has no objection to the application. And that the appeal may be heard on merits. So similar submission is made by Mr. R. Kaushik, and application will be closed. Considering the above, and upon perusal of the materials available, we are inclined to condemn delay. So accordingly, delay of 11 days is good. The application stands alone. Then where is the appeal?
Now appeal will come for admission, my. It is not numbered yet.
The registry shall now number the appeal and post the matter for admission. After a week,
Next week, next Monday, madam, admission might be just admission. And again, matter will be there.
okay then. Great.
This may come Friday also, my lord, as your worship. Friday.
16th.
This Friday, no problem, my lord. Only admission, my lord. This statutory appeal, otherwise your worship will be pleased to admit, my lord. Then thereafter, my lord, we will file that. That's why I'm saying. Ultimately, you have to come to register, man. Ultimately, you have to come to register. That's why I'm saying, man, that it will Friday, my lord. Registry will, my lord, list it on the basis of the number, my lord. Then, if your worship desire, it may be admitted, my lord. Then it will contact with them.
All right, Friday, give the date. List the
Obliged
dates.
to us.
My lord, memo of appeal. may be
Yes,
given
yes,
to-
yes. Everything will get.
Give him a copy.
Obliged to. Will you, huh?
Before that, 35, we need to pass any order.
35, I think, let it come on Friday along with that, madam. Ultimately, both are
35, you write, list this matter along with criminal appeal number.
on the order column.
Sorry.
Oh, and
Leave this appeal.
admission.
There is no number also. So,
No, 35 number is there.
okay, okay.
35 240, criminal appeal number.
We got it. Okay. All right.
Well, item 38. Yeah, I need some accommodation because the file was not with me. Thus, during the course of the break, I got a paper. It was in our office, madam. Somehow they misplaced and again they submitted.
How much time do you require?
Well,
So much.
any short date. Not a big.
Next week.
I can send you appearance of this one.
My lord,
Number 2.
name is showing, my lord.
Mr. A. Alam, some.
Yeah, alarm is there. Okay, Mr. R. Kaushik, learned additional quickly. Service that we need some more time to prepare the matter, the place for adjournment. So then you prepare. The matter stands adjourned. When?
Any day. As per convenience of this court.
List again on 22. List the matter on 23 for hearing.
Can it be on 21 or 28, 28, sir?
No, right here, 28.
Obliged.